It is Thursday afternoon, 4 o'clock, January the 11th. We are going to reconvene the special meeting of the Board of Johnston County Elections to deliberate and adopt our order from yesterday's meeting. At this time, I'd like to call on our counsel, Jennifer Slesser. You'd come forward, please.
Good afternoon, Mr. Chairman, members of the board. Yesterday, you heard the candidate challenge in the matter relating to the qualifications of David Marshburn for Johnston County Board of Education District 7. And today,
Election.
pardon me?
Election. Education.
Elections, education, and commissioners. We do it all. And I apologize for that. Thank you, Ms. Bill, for correcting me. But with regards to that, you heard that, you made the decision, and today we were going to come back together to adopt the board's written decision, and I drafted that for your consideration. It is at your seats. In the interim, we received a motion from the challenger, and the motion was to hear additional evidence to modify the judgment rendered, a motion to hear additional evidence and modify the judgment rendered on newly discovered evidence. And I don't want to misspeak because I didn't really pay that much attention to what time I got it, but it was around 2 o'clock today. I heard that it may be coming last night, got confirmation from the challenger's attorney in the 1 o'clock time frame that there was an intent for that motion to be filed. And so we have received that. You have copies of that at your seat as well. And just preliminarily, and this is what Mr. Tu and I discussed yesterday, this hearing is not governed by the rules of civil procedure, and there's not really a procedure under the candidate challenge statutes that contemplates this sort of thing. I will say, though, however, if one were to use the rules of civil procedure as a guide, then perhaps it is something that you could consider. And essentially, I think, and we'll let you hear from the parties if you choose to, but I think that really what has been requested is for the opportunity to be heard on what has been described as newly discovered evidence, and the reason that the motion was filed at this point is because the order has not yet been adopted. So, and of course, under the rules, we have to adopt a written decision. So that was, I think the reason that it was handled the way in which it was. And I told Mr. Tu when I spoke with him yesterday that if he were going to file a motion, that I respectfully requested that he do it immediately, and he notified, and that he notify Mr. O'Hale. And as you can see, Mr. O'Hale is here, so Mr. O'Hale was notified. So that's what you have before you, and you it is discretionary as to how you decide that you want to move forward with all of that. And I will sit down and be quiet and let you do as you so desire with regards to this new preliminary matter that has been submitted. Thank you.
Thank you.
So we need to look at it.
All right. So, as it was outlined, we're not required to do this. It is an option of the board if we would like to reopen and hear this motion, and then at that time we can decide on whether to proceed forward to have the evidence presented and whatever. So
we need. Do you think we need time to look at this that we were presenting, the information?
you're welcome to, yes. That's the pleasure of the board. If you'd like to read it, I was going to have both councils make their argument of why we should or shouldn't hear, or the reasons for hearing it. If that's all right.
Yeah, it's fine.
Okay. At this time, Mr. Tu, if you'd like to present your motion.
Thank you, Mr. Shallcross. Shall I remain seated?
Yes, as yesterday.
Okay.
Yes, sir.
Thank you. Make it easier on all. The reason that I'm here is that there was evidence that was discovered after the fact, which I wish to present, which will controvert the, let me see. That, okay, it's probably true, and it is from a video recording that was made in October 2023, I believe October 25th. It is competent and material, that is my position, and due diligence was employed and that there was no delay in getting this. The information was related by a text from a witness here, and it was discovered after the hearing. It was initially made during the hearing, discovered after the hearing, and then from late yesterday afternoon until I walked in this door, it has consumed me and my client in the preparation of this matter. It's not cumulative evidence. There is substantial evidence relating to the critical issue which you all discussed, and that was abandonment. It not only contradicts the witness, and I would say impeaches and or discredits him, and that if it was heard, there would be a different result. Now, as a matter of law, when an order is rendered, and you all have rendered an order, that order has to become final. My position is that if you use as a guideline the Rule 52 of the Rules of Civil Procedure, which relates to a post-entry, meaning that it has been finalized, then a motion to amend the findings of that judgment would be appropriate. Here, it would be, it seems to me, appropriate to do this because there certainly can be an appeal, and as a part of the appeal, whether to the appropriate court, Superior Court, or to the Court of Appeals, there would be a motion to amend the findings. The second thing is that the Rule 59 permits a judgment to be amended, and in order to do that, there would need to be additional evidence. And then the last, Rule 60 provides under Rule 60B6 that a judgment or order, and keep in mind, again, that deals with once it has been entered, i.e. finalized and filed, it can be amended upon a number of factors. One is for good cause shown and other relief just in the interest of justice. And so here we're talking about not only that, but the issue of due process here. There are no written guidelines, and so as you've heard the county attorney say, that the rules of civil procedure can be guidelines. So the reason I argue is this. if you are considering the impact and the dealing with this, then it would certainly be in your discretion, I believe, more prudent to deal with this newfound evidence here and make your findings of fact with regard to the issue of abandonment, where he not only has his residence but has intended to resign. The gist of the facts are that on October 20, I believe it's October 25th, 2023, he was,
Who's he?
excuse me, the applicant, thank you, Jack. The applicant was transmitting from his home. And at 37.08 minutes, he says, and this is back in October, he says, like it should for Johnston County, that's where we are going to, what we are going to do. Now, it is going to take some time to get back started on it and get everything done. I brought my podcast stuff back to where I can do this on a regular basis, because it was hard for me to go from here, and that transmission was from his home to the office where he has testified that he lived, and he and his wife lived separate apart. There to do a podcast, then come back, then go back and go back, back and forth,
Mr.
back
Two,
and forth.
Are you entering that as testimony now, or are we just?
I'm arguing
All right, sir.
what it will show, and it's up to you as to whether or not there's a hearing to receive this additional evidence.
Okay.
Finally, I just walk up.
It's right.
So he's talking about walking up, so he's in his house to do the podcast. Done, do another one, but as things are coming in, I know I'm forgetting something. So the gist of it is this: it directly contradicts his testimony as to where his domicile was and whether or not he has the intention of returning home. And keep in mind that there is also testimony that he was not taking his equipment to the rental house, 30-day termination, until he could get it set up. So that's the gist of the evidence that I have, and ask respectfully that in your discretion, you reopen the hearing to produce this evidence, and this evidence only, which should not take a long period of time. Thank you. I respect and appreciate your tolerance.
Thanks, sir. Your rebuttal?
Chairman Shallcross, members of the board, it's becoming to be my home away from home here as well this week. Frankly, I think Mr. Two is full of blarney, and I'm going to tell you why. He talks about due process. I was in my office when I got a call during the luncheon hour sometime after 1 o'clock saying that he was going to file this motion. He wanted an email address. I said, well, what's your newly discovered evidence? And he told me. I said, well, here's my email address. Now, he never said anything about having a hearing on this at 4 o'clock today. I returned to court at 2 p.m. where I was when my office called me and said that they had reviewed the motion that he had filed, and that he wanted to have a hearing at 4 o'clock. Now, when Mr. Two called me during the luncheon recess, I called or attempted to reach my client, Mr. Marshburn, and his voicemail was full. I left the number of his message at his office. Mr. Marshburn did not return my call until 3:53 p.m. So if Mr. Two wants due process is adequate notice to be heard at a meaningful time. Now, my client has a right to be here. Now, if he's having ex parte communications with your counsel yesterday telling her about the motion, I should have heard about it so I could notify my client. That did not occur. Under the law, this is not newly discovered evidence. This is evidence that was out there in the public domain that Mr. Johnston had access to. And the fact that he wasn't diligent in pursuing the preparation of his case is not newly discovered evidence. If he wanted to find it, he had it. He just didn't follow up on it. Now, under the law, as I understand it, and this is something I've learned from listening to your very learned counsel, because frankly, I did not know what rules govern this, but my understanding is the rules of civil procedure do not govern this. Now, if we're going to have a hearing on this motion, then we have to have due process, that the public be notified, that my client be notified, and then we come in and have the right to cross-examine Mr. Johnston and what he did or didn't do in preparation of the pleadings that he filed challenging. He's the person who put this case out there. I would say respectfully that if you do any legal research, which I would plan to do, I would demonstrate the law would say that this is not newly discovered evidence. If he's had this in his possession for this period of time, he should have discovered it. His counsel should have told us yesterday that he was planning on doing this, since he told the county attorney but didn't tell my client or myself that this was going to happen. And I would say to you that this is an issue of podcasts that took place in October of 2023. As Chairman Shawcross pointed out yesterday, the legislature didn't even pass the statute, as I understand it, until November the 15th, that they're going to have school board elections out of districts. So what happened in October 23 is not germane to anything that happened pre-November the 15th, 2023. And I would point out this is something that happened in October, when the uncontradicted evidence is that my client contacted his new landlord in December the 7th and signed a lease on December the 13th, well within the purview of what the law requires. I would say that Mr. Two's remedy is, if he disagrees with what's happened here, he has the right not to go to Superior Court, but to give notice of appeal to the State Board of Elections and let them review it as the law permits. And then after that, if he wants to go to court, it could end up in the Court of Appeals. But the Superior Court has nothing to do with this. And I would just say we had our full and plenary hearing yesterday. Everybody had to have a chance to bite of the apple. They rested their case. Mr. Johnston, as you know, the first time he showed out with counsel. My client did not have counsel. You were very kind to me and my counsel continuing the case until yesterday. And Mr. Two wants some time to prepare for this so we can notify the public to be present, the voters to be present, my client to be present. We would welcome that opportunity. And I would be happy to respond to any questions that you might have. And again, thank you for your courtesies.
Thank you.
If I may respond, this has a short fuse on it. This was something that was learned late yesterday. And before making a final decision, I believe I noticed that I was considering doing that. I want to make sure that I feel comfortable that there is a legal basis for this. Otherwise, and I know you've got to make a decision, and you're looking at, okay, I understand what he says, and that is true and accurate, but given the time limitations that we had, this is why we are here. If there is a prospect of an appeal, and again, the election law is a mess. What I have determined, and what happens is apparently the legislature keeps messing with it, but noticeably it's not under the Administrative Judgment Act, under that jurisdiction, which provides a lot of guidance. And the other thing, it is exempt, but as she has said, it is for, I guess, persuasive law to consult the rules of civil procedure. So two things. One, there is clear evidence that contradicts the essential issue here, and that is abandonment. And again, I would agree that a hearing on this after appropriate notice, and the notice was all I had under the time, and I did not make a decision until I was up late last night. I was up at 6 o'clock this morning researching the matter and gathering the facts and putting it together to file, at which time I called. So, thank you.
Thank you. Okay. We're not governed by civil proceedings. We're not governed by administrative law. Right? There are procedures, that was outlined for doing amendments under civil procedures. Should we open this up for a hearing, we'll have to reschedule and give the candidate a chance to do that.
Which then makes it a write-in if we're not through. She's got to do the,
Well, yeah, it does complicate the ballot timeline. There is one other way, and that is that should we choose not to hear this motion or deny this motion, then if there is an appeal, this can be heard at the state board of elections at that time.
there's still recourse.
There's still recourse for them.
Well, I don't,
Mr. Shellcross, may I comment on that?
Please.
yeah.
I believe that it wouldn't necessarily be this particular motion that would be heard. I just want to clarify, and I think this is what Mr. Shellcross meant. This particular motion wouldn't be heard, but certainly the challenger could raise that as an error of the board as part of the appeal process. So I just wanted to clarify
Okay.
that statement for the board and for the public.
Thank you.
Right. I think it's pretty clear that we can't do anything without Mr. Marshburn here. Whatever, if we're going to go on with it.
But does it change the fact that we have a lease and a driver's license?
I was just going to say, do we think that this October 25th, 2023 information is going to be pertinent after we've already?
No.
No, yeah.
No.
I mean, that didn't play into any of our deliberations as to.
No.
Okay, is there a motion to?
Motion to deny the appeal.
There's a motion. There's a motion and a second. Any discussion on that motion? I since you're ready to vote, all those in favor say aye. Aye. All those opposed, like sign. Motion carries. Your,
Thank you. I
motion
appreciate
is
your
denied.
patience and tolerance.
Thank you.
Yes, sir.
All right, the next item on our agenda is our decision. You have that in front of you, and it goes down to the why don't you take some time to peruse through it? Yes.
Yeah. Thank you.
I was fortunate to catch it before I left the office, so I gleaned through it one time already.
The appeal period, is it 10 or 30?
2 business days.
2 business days?
2 business days after the,
Okay.
It's like a transcriber or somebody who's typing this.
you know what's so interesting, and I just throw this out because you're probably smarter than I am. The statute says this is an inferior court, so if it's a court,
But if I'm thinking correctly about that.
I tried to,
There was no change in the so-called, this part. It was the same information as it was on the first one.
There was more added to it.
And in this, okay, she's got Board of Education in this also. Should that be Board of Elections?
What page?
On
Page
page two,
eight.
page two.
No, they have.
Is it on page 8 also?
That's correct.
Here?
Yeah, he's
Yeah,
in
that's
the
correct.
Board of Education race.
Oh,
Yeah, the citizen, the opportunity to have its Board of Education composed of 7 members.
no, this is number 8. In October 2023, the North Carolina GA passed a bill granting Johnston County citizens the opportunity to have its Board of Education
Yes,
composed of
that's
7
correct.
members.
Yeah.
But we're the Board of Elections.
We're not,
That-
that's not about us.
No,
Oh,
that's,
okay.
that's when,
Okay,
that's when the
okay.
legislature separated,
Okay, gotcha.
and it was, adopted by the Board of Education
Okay.
on November 15th, 2023.
And I think that was the testimony yesterday that you heard, was that the legislature had given the Board of Education that opportunity, and then the Board of Education
excuse
took
me.
it.
I'm
in
getting my boards mixed up.
November 15th. I understand, Ms. Bill, I understand.
Our names are too close.
And if there are any particular questions as you're reading through, I'm happy to answer those. And if there's anything about the order because this is a draft and it's your order, so if there's anything that you want changed, then obviously I can do that. Run back to my
Okay.
computer and make whatever change you may wish.
Oh, yeah, right.
And
We're
it
still
would-
being recorded, right?
Yes,
Yes.
we are.
And it would have been a whole lot better had they made this particular law effective as of a future date
Yeah.
and not immediately.
Well, the Board of Education was pushing it.
Okay.
Looks good to me.
Yeah, that's what I thought too.
I still wish there was proof of that, of 13.
You what?
I still wish there was proof of 13.
Which
I
one are you looking
understand.
at?
13.
Which number 13? I'm not there yet, okay.
And Ms. Zink, that number 13 was taken from the testimony
I
that you
know.
received.
But we had no proof of that.
With documentary evidence.
Right.
You had sworn testimony about it.
Yeah.
Which is the same thing. Or it's viewed in the same
In this case, it has to
light,
be, yeah.
right? Am I
Well,
wrong?
there's testimony and there's conduct. So there's two things. And you considered both of those yesterday. You considered the testimony that you received, and you also considered conduct that went with those statements. So, and I certainly understand. But based on the evidence that was before you
That's all we can do.
today, certainly you have the ability to judge the credibility of the witnesses and all of those sorts of things. But again, we took the findings based on your deliberations and based upon the recordings. We rewatched the recording yesterday.
Excuse me just 1 second. I'm going to grab a pen.
That
You
one
need a
didn't
pen?
write?
John, I've got plenty of pens.
No, just-
That one didn't write?
Well, yeah, it did, and I also needed a cough drop. But
Okay.
y'all wanted
That's what
you wanted me to admit it, okay.
motion for
Please.
this?
Yeah.
Okay.
Motion to adopt the order.
Are you ready? I move
All right, the chair would entertain a motion at this time.
we adopt the order as written.
Second?
There's a motion and a second. Is there any discussion? Seeing none, you ready to vote? All those in favor say aye. Aye. All those opposed, like sign. Motion carries. The order is adopted. At this time, is there a motion to adjourn?
Move for adjournment.
We are adjourned.